Hey everyone. Now that I've gotten my system set up a bit better, I wanted to thank my supporters for supporting my work. As a direct result of your support, I now have a viable mobile setup where all my recording gear fits into a large laptop over-the-shoulder bag. My mobile mic is a Samson Meteor mic, and in my last video, I used my Blue Yeti, but rather than connecting it to my system via USB, which I originally did and can still do, I now connect it through my condenser interface, which I'm told gives better sound quality. Today, I'm recording on the Samson Meteor mic. The reason I tell you this is because the audio in my videos may change based on which of the three mic setups I happen to be using. Let me know how it sounds in the comments section below. Also, as you know, YouTube demonetized my channel, so if you want to support my work, the best way to do so is through Subscribestar or Patreon. The links will be in the description below. Finally, I want to thank all my subscribers and supporters. The success of this channel and my book would not be possible without your ongoing support. Thank you for helping my channel continue to grow. With that out of the way, let's get started because there's a lot of information to get through. Have you noticed that the legacy fake news media has been mostly silent on the new red flag laws? This is because they're terrified of any kind of meaningful public debate on the constitutionality of red flag laws. Why is that? It's because in order to have a meaningful public debate on U.S. citizens' constitutional right to bear arms and the new red flag laws starting to sweep the nation, it's necessary to discuss their feminist origins. That's right, their feminist origins. You see, red flag laws were not created in a vacuum. They were created by man-hating, capitalism-hating, constitution-hating, civil rights-hating feminists. More specifically, they were patterned after civil domestic violence protection orders, which, as I'll outline in this video, are just as unconstitutional as the red flag laws currently being passed in socialist strongholds throughout the country. Fun fact, if your state has passed or is about to pass a red flag law, congratulations! Your state is an un-American, anti-constitutional rights socialist shithole. With that out of the way, let's move to the United States and Texas Law Shield Legal Defense blog. This post was created on April 15, 2019, entitled Legislative Update: Red Flag Law Passes in Colorado. Let's touch on the highlights. Now, these EPROs stand for Extreme Risk Protection Order. Now, who may request an EPRO? A family member, a household member, a law enforcement officer, or agency. Now, I want you to remember that this is a civil action, but the government can institute it. I want you to understand that. That is a violation. I believe it's the 4th and the 6th Amendment, where Americans are entitled to, I believe it's to pursue life, liberty, and the pursuit of happiness, free from government interference. I also believe it might be a violation of the 14th Amendment as well, under the same reasoning. But I don't remember off the top of my head because I haven't looked at all of it recently. But you understand where I'm going from. Now, the parties involved are the petitioner, which again could be a household member, a family member, a law enforcement officer, or an agency, okay? And the respondent is the restrained party. Now, here's the thing. Let's say the neighbor calls the police on you, but they don't have any reason to charge you, but the officer just doesn't like you. He can file one of these orders against you, ex parte, and on top of that, he can go in and take your guns with no notice, even though you're not guilty of a crime. I want you to remember that. Now, let's talk about temporary Er Pio hearings. To obtain an Er Pio, the process starts with a hearing. The petitioner starts the Er Pio process by submitting an affidavit signed under oath and penalty of perjury that states the facts and evidence in support of a temporary Er Pio. Now, I'm concerned about this because in family court, women and mothers commit perjury all the time. And the courts are told of this, and they do nothing to prosecute this. They don't recommend law enforcement investigate. They don't hold the person committing perjury in contempt. And we see this all the time. This is like the basis of the Me Too movement is perjury. This is why they don't file criminal complaints when they falsely accuse men of domestic violence and sexual assault. They do it in the news, they do it in civil court, they do it elsewhere. And what a lot of family court judges have realized is that many times an affidavit signed under oath under penalty of perjury is not even worth toilet paper. All right. Now, this request can be filed without any notice to the respondent. I want you to understand that. So the person has no idea that this is happening. If the petitioner is law enforcement, an affidavit for a search warrant must also be filed to search for any firearms in the possession or the control of the respondent. Now, this is important because, again, the person who is the target of this ERPO, of this extreme risk protection order, they don't have to be somebody under the investigation of a crime. In other words, they don't have to be a potential criminal. There doesn't have to be an ongoing investigation. They could be a law-abiding citizen that this police officer just doesn't like, okay? And then they're going to get a search warrant to search your house. And if you violate that search warrant, or in other words, if you stand in opposition to that search warrant, which, by the way, you've never been given any notice of, that police officer can shoot you legally and kill you. And we've already seen these gun confiscation laws in other states in the country, not just Colorado. And there've already been American citizens with no criminal records who've been murdered by police officers trying to enforce these sorts of gun confiscation laws. So I want to remind everybody of this because this is a serious issue, all right? Now, the courts must hold a temporary ERPO hearing on the same day the petition is filed or the following day. Now, what that means is this is what's called an ex parte order. There's no hearing. You just go in front of a judge. I don't even think it's on the record. I know domestic violence civil protection orders are not on the record. They're not recorded in any way. So when you initially get your petition, it's not on the record. It's considered ex parte because the person who's the target of these orders is never notified until after the judge signs it. Okay? Now here's the other piece. The petitioner must establish proof by a preponderance of the evidence that the respondent poses a significant risk to him or herself or others by having a firearm in his or her custody or control, or by possessing, purchasing, or receiving a firearm. Now, the preponderance of evidence is the lowest standard of proof. And again, there's no cross-examination, there's no notification, there's no due process protection in place that allows the person being falsely accused to defend themselves. They have no defense, and the standard of evidence is extremely low. This is why in family court, a lot of family court professionals, they complain that domestic violence civil protection orders are given out like candy. These will be given out like candy as well in every socialist shithole that passes these laws. And let me tell you something. If your state was traditionally conservative and yet your legislature has passed one of these laws, congratulations. Your state is no longer conservative. It is now a socialist shithole that is an anti-American shithole and an anti-constitutional rights shithole. So I want you to understand these actions have far-reaching consequences to any American's right to bear arms, any American Second Amendment right. Okay? Let's move on. The respondent must be served with the temporary ERPO, the petition for a temporary ERPO, and the notice of the continuing ERPO hearing. If the respondent attends the court hearing, he or she must relinquish firearms and concealed handgun permit within 24 hours of the hearing. The temporary ERPO expires on the date and time of the continuing ERPO hearing. Now, remember, though, that if the law enforcement officer is the complaining party, which they can be, and they have a search warrant, when they serve the ERPO, they can go through and toss your house. And I mean toss your house. Have you ever seen a drug house get tossed with a search warrant? They destroy everything. They destroy everything. So if you're a law-abiding citizen and these cops show up with an ERPO and a SWAT team and you resist them, they can shoot you and then destroy your possessions all under the color of law. How is this not a due process violation? Okay? Now, here's the thing that's really telling here. A continuing ERPO must be scheduled within 2 weeks or 14 days following the initial order. Now, I want you to remember this because it is extremely important. Now, the factors that the court may consider, now I'm only highlighting some of them because the other ones are somewhat valid, I think. These are the ones I think, though, are ripe for abuse. a pattern of acts or credible threats of violence by the respondent. In other words, if somebody says that they were threatened, the court can go, okay, well, we believe you're threatened and there's no evidence otherwise. Why? Because it's an ex parte order and nobody's been given notification of it. The second, a violation by the respondent of a civil protection order. Now, civil protection orders, as you're going to see later in this video, they violate men's due process rights, and they are a form of gender discrimination used to demonize and disarm men and destroy families. Because even when mothers and fathers get a divorce, the man should still have a right to raise his children. Here's a fun fact. Did you know, since we're talking about like gun rights and gun laws, did you know that 96% of all mass shooters in the United States were raised in broken homes? In other words, these are homes where the biological father is not present. Either the mother is remarried or it's a single mother. It's a childhood home of a single mother, or it's a child that's been raised in foster care. So when you destroy the family, you're creating criminals. I go into this in my book, The Feminist Lie, in chapter 3, in the differences between children raised in broken homes, like what I'm describing here, and children raised in homes where biological mother and biological father are raising the child together and are following traditional American Judeo-Christian values. So I want you to understand that. So civil protection orders, in other words, if you are a victim of due process violation by having a civil domestic violence protection order issued against you, and there's evidence of that in the record that you violated it, whether you knew or not, and I know plenty of guys who never knew that they had a civil protection order against them, they reach out and they communicate with their ex or with a family member that has gotten it against them, and then they go to jail for it. So if you violate a civil protection order, you're done. They can take your guns. The respondent's ownership, access to, or intent to possess a firearm. Do you want to own a gun? Are you a law-abiding American who believes in your Second Amendment rights and you want to own a firearm legally? Fuck you. Because they can get an Er Pio against you because you are an American constitutionalist who believes in your right to bear arms. Remember that, okay? This is in the state of Colorado. Many other states have patterned their laws or are trying to pattern their red flag laws after this bullshit right here, okay? Evidence of abuse of drugs or alcohol by the respondent. You know, on New Year's Eve, did you guys drink a lot? Did you have a bunch of beer cans in the garbage can? That's evidence of abuse of drugs or alcohol, according to the court, and they can use that against you. What if you recently purchased a firearm? According to this, evidence of a recent acquisition of a firearm or ammunition could be grounds to take away your gun rights. Okay? They will give these out like candy. These clauses are ripe for abuse. Now, during the hearing, both the petitioner and the respondent may present evidence and cross-examine witnesses. Well, that's bullshit. And you're going to see that later in this video, because the reality is that when it comes to civil domestic violence protection orders, which, by the way, have been in existence for well over 2 decades, almost 3, cross-examination of witnesses never, ever happens. All right? But this is important as well. The court must order the respondent to undergo a mental health evaluation and treatment if the person qualifies. In other words, if the judge doesn't like you, or you're standing there going, why are you violating my Second Amendment rights? The judge can order a psych eval against you and have you declared incompetent. Or maybe what they could do is they can do a mental health involuntary hold against you. Thereby, even if they don't get the order against you, that will still impact your right to own a gun, and it could impact some of your other civil rights as well. In addition, see right here, here's the part right where I was talking about. Additionally, the court may initiate emergency commitment of the respondent. In other words, if I don't like you, or I think you're a piece of shit, or I just hate men, I can have you involuntarily committed. Okay? I want you to remember that. I can have you, if I'm the judge, I could have you involuntarily committed because you recently purchased a gun or because you own a gun. So what we're saying here is that don't be surprised if the American Psychological Organization or some other bullshit leftist organization turns around and goes, well, that person owns a firearm. Clearly, we need to include this in the DSM as a diagnosis, and then we need to commit the person to a mental institution or some sort of other jail under false pretenses because they own a gun. Oh, and if you resist, we will fucking shoot you dead. I want you to think about that. because that's the reality of the situation. Congratulations, Colorado. You're now fucking Russia, communist Russia's little fucking brother. That's the reality of that, okay? Now, let's talk about the women's law blog, all right? Now, the reason I bring this up is because, again, I talked initially in the introduction to this video about how these red flag laws, they have their basis in feminism, okay? Now, according to the women's law blog, this is federal information. Under federal gun laws, it is illegal for the abuser. This is a person convicted of a civil domestic violence protection order, not someone who's convicted of a crime, a person who they've been the subject of a civil domestic violence protection order, which are given out like candy in feminist family court. It is illegal for the abuser to buy, own, or have a gun while you have a final order of protection. The only requirement is the order is issued. That's it. Fuck you. Fuck your gun rights. Here you go. Now, the federal law in question is 18 U.S.C. subsection 922, subsection G, subsection 8, which states, who is the subject to a court order that was issued after a hearing in which such person received actual notice and at which such person had an opportunity to participate, restrains the person from harassing, stalking, or threatening an intimate partner of such a person or child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child, and includes a finding that such a person represents a credible threat to the physical safety of such intimate partner or child, or by its terms explicitly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child that would reasonably be expected to cause bodily injury. Okay? Now, that's important because this means that you don't have to be involuntarily committed because of mental health issues. You don't have to be convicted of a crime. You just have to be the subject of a civil domestic violence restraining order, which, by the way, studies have shown, I think it's between 70 and 80%, are based on fraud. They're based on false accusations. They're based on Me Too, hashtag Me Too bullshit. I want you to remember that, okay? Now, interestingly enough, there's been some pushback on some of these laws. Now, in the state of Ohio, and let me see if I can find here. This was in 2017, okay? The court held that CPO condition that banned firearms possession was unconstitutional on the facts of the case. So in other words, what they said was that even though they were terrified because they're gynocentric cucks to strike down the laws being unconstitutional, they said that for purposes of this case, the law was unconstitutional. And the CPO is a civil protection order. It's a civil domestic violence protection order. Here is the meat and potatoes of this particular video. And this is why I have such an issue with it, okay? Now, according to Cornell, due process, this is a conversation about due process. I've used this in other videos before. This is the due process gift that keeps on giving, okay? While there is no definitive list of the required procedures that due process requires, Judge Henry Friendly, I believe he was on the Supreme Court at one point, generated a list that remains highly influential as to both content and relative priority. Number 1, an unbiased tribunal. In other words, a judge who doesn't have bias. Number 2, notice of the proposed action and the grounds asserted for it. Number 3, the opportunity to present reasons why the proposed actions should not be taken. Number 4, the right to present evidence, including the right to call witnesses. Number 5, the right to know opposing evidence. Number 6, the right to cross-examine adverse witnesses. Number 7, a decision based exclusively on the evidence presented. Number 8, the opportunity to be represented by counsel. Number 9, the requirement that the tribunal prepare a record of the evidence presented, which, by the way, is never done in ex parte civil protection orders and won't be done in the extreme risk protection order laws that were passed by Colorado and other socialist shitholes. And then number 10, the requirement that the tribunal prepare written findings of fact and the reasons for its decision. Now, Let's dig into some of that a little bit. I'm not going to touch on every one of these things, but let's touch on the ones that are relevant, okay? Civil protection orders and red flag laws violate due process rights as follows. The accused is entitled to an unbiased tribunal. Here's the problem. Judges trained in the Duluth model of domestic violence intervention, or any domestic violence intervention based on any aspect of the Duluth model, including patriarchy theory, is by definition biased. The Duluth model was based on fraud from the beginning, and patriarchy theory is a redefinition of the term patriarchy based on feminist bigot theory, not based on actual facts or dictionary definitions, okay? I go into this in detail in my video, Duluth Feminist Brainwashing and the Ideological Subversion of Society, which I published on YouTube and on BitChute on December 2nd, 2017. Number 2, the right to present evidence. The civil protection order hearings are accelerated hearings. Typically, this means that from the time the accuser files a civil protection petition to the time the petition is heard is 14 days, which is exactly the same as extreme risk protection orders. This is not enough time to collect and present evidence in any meaningful way. Now, the reason this is because most states' civil discovery procedures give a minimum of 20 and often 30 days for a party to respond to interrogatory discovery. Non-attorneys are barred from issuing subpoenas, leaving the interrogatory the only investigative discovery tool available to a non-attorney being accused to compel any kind of investigation or discovery. Now, without an opportunity to issue discovery or subpoenas, or to use the interrogatories, one cannot meaningfully or credibly present evidence to protect oneself against either a red flag or a civil domestic violence protection order. Now, the other piece that's extremely important here as well, if we go back to due process, right, and we look at number 4, the right to present evidence, including the right to call witnesses, the way witnesses are called in the United States is by subpoena. A non-attorney cannot issue a subpoena. So you have no right to call witnesses. That particular due process protection does not exist for you. Go fuck yourself. That's what they're saying. Okay? Number 3, the right to know opposing evidence. Now, because these hearings are accelerated, and in practice, they bar any meaningful discovery because there's no opportunity to fully know the opposing evidence, only the allegations. In other words, if you have a discovery phase in a normal civil trial, you'll start your trial and then there'll be a whole section of the trial. Usually it's about a month or 2, maybe 3, where it's called the discovery phase. This is where you issue subpoenas. This is where you deposition the opposing party. This is where you look for records. This is where you question witnesses. You don't get any of that in either of these hearings. You don't get it in the domestic violence civil protection order. You don't get it in the extreme risk protection order either. Okay, so that due process right, go fuck yourself. You don't get it. The right to cross-examine adverse witnesses. The domestic violence courts never allow this, and I mean they never do. When you walk into the domestic violence court, they will always bar your witnesses if you're the accused. I mean, I've seen it happen where sometimes they'll allow it, but honestly, in the majority of the cases, they bar it. And the reality is that without the ability to subpoena a witness, they can't get time off of work to show up for court. And there's no meaningful way to compel them. In fact, when it comes to many court cases, especially in family law, even if you issue a subpoena, the judge never enforces it. Not if you're a man. Okay? Now, the red flag courts, even if they did allow this without any kind of meaningful discovery, they prevent meaningful ability to cross-examine any adverse witness, especially if the accuser has a history or a habit of filing either a DV or red flag orders against others, or is otherwise not a credible witness. Now, why do I bring that up? Why do I state that? It's because I helped a guy in Seattle, probably somewhere between 2013 and 2016, and he was being accused of domestic violence. It turns out that the hag who falsely accused him of domestic violence, okay? She not only falsely accused him of domestic violence, but she had filed like 5 domestic violence restraining orders against ex-boyfriends all throughout her adult history. So you have to understand that sometimes people just do this shit, and because they're given out like candy, you have no way of knowing this on an accelerated basis. How do you know if the cop who filed the extreme risk protection order against you, how do you know that he's not a feminist bigot or a cuck who's thirsty for female attention, where they're filing this for some untoward circumstance, or they have a history of unethical conduct. You have no way of cross-examining that police officer to find out if they're corrupt. You have no way. With a 14-day accelerated hearing, that is not possible. So you don't really have any right to cross-examine a witness. That due process protection, go fuck yourself. You don't get it. All right. A decision based exclusively on the evidence presented. Now, in front of a judge who is trained in the Duluth or any other domestic violence intervention program based on Duluth or patriarchy theory, this is not possible because the judge is biased against men at the outset. And in practice, civil domestic violence judges will grant orders as a precautionary measure out of concern, not evidence. And this is true. They'll be like, well, I don't see any evidence of domestic violence here, but I'm going to go ahead and I'm going to grant the order just because I'm concerned. Well, look, judge, it's not your fucking turn at therapy. If you need therapy, go see a therapist, but don't try to role play your therapy out and take it out on a man falsely accused of DV. Nobody gives a shit about your feelings. That's the reality. The reality is that these orders need to be presented on evidence. They can't be presented on, I have a feeling. Your feeling doesn't translate into evidence. There has to be some facts behind it. And finally, these laws do not ensure that the accused has a right to an attorney. This is never allowed. It's never allowed. You're going to lose your gun rights and you're not going to get an attorney. This violates your due process. You have a constitutional right to bear arms, and they are denying this, and they're not even giving you the opportunity to have an attorney. Okay? These laws are a socialist machine to disarm Americans. Make no mistake, they're a violation of due process. They're a violation of American civil rights. And anyone who tells you that they support civil domestic violence protection orders or red flag laws, they are not civil rights activists. They are un-American socialist bigots who want to disarm Americans, whether they're too stupid to figure it out or not. Now, as you can see, both red flag laws and DV civil protection orders that bar Americans' constitutional Second Amendment right to own a firearm are unconstitutional on their face because they violate the due process rights guaranteed by the Fifth and the 14th Amendments of our United States Constitution. However, when feminists were taking fathers' gun rights away, everyone was silent. Now that feminists and socialists want to disarm all Americans, everybody's acting all shocked and surprised. Even the tradcons are acting completely surprised. Why is that? I only ask because it was the tradcons and the conservatives that helped pass these laws that violate Americans' constitutional rights to own guns in the first place. You see, biological science has aptly demonstrated that you cannot have a family without a father. So why would tradcons and American constitutionalists of conscience stand by silently while feminist family courts violate due process to persecute fathers and to wrongfully destroy families every day? There is no excuse for it. And the reality is this: due process violations are not a men's rights issue. They're not a father's rights issue. They're an American's constitutional rights issues that affects every American, every man, every woman, every child, every American citizen. And those who seek to wrongfully deprive American citizens of their Second Amendment right to bear arms are not only anti-civil rights, they're anti-American. You see, socialists and communists cannot overrun our country and destroy it without disarming its citizens. And make no mistake, communists and socialists want to actively disarm Americans in any way they can, whether it be to wrongfully work with feminist bigots to falsely accuse law-abiding American fathers and men of domestic violence, like the Me Too movement does, or to bribe and extort politicians to pass red flag laws to disarm every law-abiding American who believes in our Constitution. Now, I can see people ask, DDJ, as a man going his own way, why do you care? Well, it's pretty simple. I'm an American citizen who believes in the Constitution on which our country stands. And I'm also a father who loves his family, who was persecuted by feminist socialist bigots and had generations of my family destroyed. So if you want to label me anything, call me a civil rights and family rights activist. The simple reality is that you cannot have a family without a father. It's not biologically possible. Also, and make no mistake, social justice, socialists, communists, and leftists are not advocating for civil rights as defined by our United States Constitution. For decades, they've been actively attempting to destroy our Constitution and the civil rights it guarantees as the basis of our country. This is why they're anti-gun, anti-free speech, anti-capitalism, and are doing everything in their power to stop America from being great again. It's why they persecute American citizens who wear hats stating, "Make America Great Again." Here's how you can easily spot these enemies of our Constitution and enemies of American families. Anyone who advocates censoring speech on the grounds that it is hate speech is un-American and an enemy of our Constitution and civil rights. Anyone who speaks in favor of taking away Americans' constitutional right to bear arms without being criminally convicted of a crime or being found completely mentally incompetent is an enemy of our Constitution and our country. Anyone who speaks out against the biological reality that families are created by men and women together is an enemy of our American way of life. Anyone who discriminates or harasses white men or women based on their race or gender is a racist and sexist bigot and is un-American and in violation of American civil rights. Anyone who discriminates or harasses any American citizen for standing up for any of the constitutional rights or civil rights that I've outlined in this video is guilty of national origin discrimination and a bigot. This is a violation of federal laws on national origin discrimination, and Americans are protected under these laws for being discriminated against for their sincere belief in our constitutional right to free speech, right to bear arms, and other civil rights protected under our Constitution. This includes, but is not limited to, banks, social media platforms, and the left-wing Democratic Party, socialists, and everyone else who discriminates against Americans who believe in our Constitution and the civil rights contained within it. If you're an American citizen and you believe in civil rights and our Constitution on which our government stands, now is the time to speak out against un-American bigots who hate our Constitution, those who hate our families, those who hate our way of life. Because if you don't, these enemies of our Constitution and our way of life will continue to destroy our country, one community, one family, and one man at a time, until we have nothing left. Don't believe me? Look at California. Look at Oregon. Look at Chicago. Look at Seattle. Look at New York. Our country is under communist assault right now, and these bigots want nothing less than to turn our country into a socialist wasteland like communist Russia was or like Venezuela is today. As an American civil rights advocate and a family rights advocate, I know you cannot have a family without a father, without men and fathers armed with firearms as guaranteed by our Constitution. Eventually, we will have no country left to defend. I'm DDJ, and this is your dose of misandry today.